through this webinar entitled COVID-19 and GDPR. First of all, we'd like to apologise for that very short delay due to technical issues. My name is James Beetham, and I'm the facilitator for this conference, and which we hope will be interesting, informative, and educational. Before we jump right in and start discussing the heart of the matter, I'd just like to present and describe the two sets of contributors that we will be hearing from today. lecocqassociate is a Geneva-based law firm historically specializing in commercial, banking, and financial law. Over recent years and months, with the growing importance of data management to its traditional banking and regulatory practice, it has earned and developed an expertise in the field of data management. It has numerous offices around the world, including Malta and Dubai, so it covers the whole gamut of data protection, both within the EU, both within Switzerland, and furthermore outside of Switzerland. Oakland Group is a data management and data analytics company based in Geneva. It too has offices in France and elsewhere within the EU. It specializes in the treatment of data and, most importantly, compliant data, believing that the only way to build true value for individual companies is actually by making that data compliant and also making sure that it is prepared and presented according to the correct legal processes within each jurisdiction. Without any more ado, I would like to present the contributors today. We have Daphne and Grech and Riccardo Varisco from lecocqassociate, and also from Oakland Group we have Fabrice, Blanc, and Laurent Marcoz. The process will be very simple. We will have a discussion of around 20 minutes, followed by a question and answer session. And indeed, we've already had one question, so we thank you very much for that. And then at the end, we will indicate how you may or may not be able to get in contact with us if you wish at a later date. So as we jump right in, can we talk about how governments have been responding initially to the COVID break? Daphne.
Of course, James, and thank you so much for that introduction. So basically, I just want to give a brief outline about the governments and their responses with respect to this whole pandemic. We've seen a variety of responses. Needless to say, there have been travel restrictions, social distancing, lockdowns, just to name a few. But the main aim of governments has always been to manage the COVID-19 outbreak and stop its spread. Even now, when we're seeing a lot of countries relaxing their measures, Spain, Germany, and Italy, they're amongst the worst hit throughout this pandemic. The idea of governments is still to control the spread and monitor the situation in order to prevent a second wave. Now, we've been also hearing about technology, and this is really interesting stuff. Technology being used for processes such as contact tracing, usage of apps to collect location data and proximity data, and a really interesting concept, governments requesting telecoms companies for mobile location data. Now, all these measures seem to be a bit intrusive into people's privacy rights, right? I mean, in order for government responses, to prevent the outspread of the virus and for everyone to work effectively, there's no doubt that personal information must be shared and obtained. And in particular, we're talking about sensitive data, or as it is now known, due to the coming into force of the General Data Protection Regulation, or as it is known now as the GDPR, special categories of data. And what I mean to say is that all these data protection laws throughout the world, including the GDPR, are informing such responses.
Great, so let's have a discussion about data protection authorities. What have they been talking about, Daphne?
Yes, of course, James. So as I mentioned, the GDPR, it's a regulation. What I mean is it's an EU legal instrument which should be directly it applies directly and uniformly across the EU. So even though the GDPR is supposed to apply directly and uniformly, the GDPR actually allows for certain matters to be legislated by member states. So member states can actually come up with specific laws. And one of the things could be, or is actually, employment matters. So we've been seeing a variety of responses from data protection authorities. They've issued statements, and there's a wide spectrum of different statements that data protection authorities have been giving throughout Europe. For example, on one hand, we see Italy and France. They've taken very stringent measures and have actually stated that employers must refrain from processing information on an employee's recent movements, and collection of such information should be left to healthcare authorities. On the other hand of the spectrum, we see, for example, Spain, UK, but really interesting, and this is what I'd like to zone in on, is Switzerland. I know Switzerland is not in the EU, but still it's really interesting to see what the Swiss Data Protection Authority has been saying, because at the moment Switzerland is coming up with its own data protection law, which should be in line with the GDPR. And what the Swiss Data Protection Authority has been saying is that an employer has to ensure that processing of health data, such as body temperature, flu symptoms, must be carried out in compliance with the Swiss Data Protection Act. Very reasonable enough, but again, this is a different approach to that taken by, for example, France. So an employer can actually collect personal data and health data on COVID. The Swiss Data Protection Authority has also said that processing must only be carried out if it is necessary and suitable with a view to prevent further infections. And whoever any data has been received from, be it employees, customers, visitors to the workplace, they have to be sufficiently informed about what's happening to their data.
Great, thank you. So at the company level, what should a director or a DPO be considering, bearing in mind the impact of COVID-19?
Yes, that's a very good question, James. So what I've been talking about, what data protection authorities have been saying, are basically, even though there's a wide spectrum, they're basically all in line with the European Data Protection Board. And the common thread between all of the statements that have been said by the authorities is basically employers have to keep in mind data protection principles. And what I mean by this is that data protection principles such as transparency, you have to give information to the data subject, you have to ensure a purpose limitation, data minimization, storage limitation, and integrity and confidentiality. Now, what I mean by these principles is that basically in practice, yes, an employer has probably, well, we've seen a lot of employers starting to process health data on symptoms and COVID-19 symptoms of employees. However, it really all depends on the particular country an employer is based in and the particular data protection national laws that would apply to that particular employer, to that particular employer's establishment. So if an employee is even allowed to collect data on symptoms of COVID-19, such as, for example, in Switzerland, as I just explained, it is recommended that an employer should ensure that only the necessary data is collected, and that data is being collected due to the emergency situation provided by COVID-19 and to safeguard an employee's health, because as we know, one of the main duties of an employer is the duty to safeguard an employee's data throughout the workplace, in the workplace, or in accordance with a law. So if a law actually allows you and is actually telling you that you need to collect certain data, such as health data in this case, then yes, by all means do so, but do it for that particular purpose. That is what I mean by purpose limitation principle. And apart from this, once the whole situation is over, or if you realize or decide that you do not need that data anymore, get rid of it. You don't need it anymore. So just go ahead and delete it, because otherwise, if as an employer you can hold on to that data, it's just going to weigh you down. It's just a liability, really. And also, one mustn't forget that since we are dealing with sensitive data, So the word is there in itself. There's more of a risk to it because of the fact of the nature of health data. It's really important that a data protection impact assessment is done. And in this case, it's really recommended that it is done. And my colleagues are going to be speaking about that further on. So please hang tight.
Great, thank you very much, Daphne. That's great. So let's dig a little deeper, please. Riccardo, Daphne's just spoken a little bit about data protection. Could you actually talk about how data protection is overlapping with general privacy law here, and what are the key considerations for a company to have in mind when processing its employees' data?
Yes, thank you, James, for the introduction. First of all, we have to bear in mind that privacy and personal data are not the same thing. Privacy is older, much older. It was invented 200 years ago in America by a famous lawyer called Warren. It has evolved through time. It has become the place where one can develop its own personality. And lately, it has been interpreted in a way that privacy is the right to live in a healthy environment, while data protection is just the protection of data, or the set of rules applicable to data. And that refers, of course, to personal data. What is a personal data? In the context of GDPR, a personal data is any information referring to any identifiable or identified data subject or person, natural person, such as an address, an email, a telephone number. And for processing those data, you must use one of the legal bases provided by the GDPR, such as consent, contract. And there are also the special categories of personal data, such as health data, biometrical data, like a normal photo, able to identify a data subject. And for those, you have to apply even more stricter legal basis. For example, I mentioned consent. An ordinary consent is requested for ordinary personal data, but for special categories, you have to acquire express consent. In the context of COVID, we are quite lucky because GDPR allows two main exceptions. First of all, Article 9, Paragraph 2, letter G, allows the processing of special categories of data for an important, relevant purpose of the European Union, such a pandemic. And letter I is even says that data can be processed in order to prevent cross-border spreading disease. So in this context, it's better to rely on those legal basis instead of vital interest, as others have proposed, because vital interest, according to GDPR, Restal 46, can be used only as last resort.
So effectively, there's no general right to privacy, and so consequently, an employer can indeed process data provided it's for a limited set of purposes.
Exactly. That's clearly that it is clearly stated in GDPR at Restal 4. Privacy is not an absolute right. You have to balance it with other rights. But still, even in this time of exception and emergency, or how the German says, Ausnahmezustand, you have to still comply with the regulation. So your records of processing activity must be up to date, or in case, according to what you're going to do, you must do a data protection impact assessment.
Excellent. So could you just outline very briefly what is a DPIA, please?
Sure. It's basically a document describing a new processing or a new methodology applied to an old processing.
Excellent. Thank you very much. Laurent, as we've heard what a DPIA is from both Daphne and also from Riccardo, could you actually start turning about the issues of the process, what one needs to do in order to compile a proper DPIA, and indeed, what is the process one needs to follow?
Yeah, thank you, James. The Data Processing Impact Assessment, or DPIA for short, is a process formalized by a written document which ensures that any personal data processing, or any major modification to an existing one is carried out taking into account the collection, treatment, processing, and disposal of personal data all along the whole life cycle. The comprises the following distinct steps and a parallel stream of consultation Without being exhaustive, there are 6 steps that include, well, first, identify and confirm the need for a DPIA, describe the information flows, identify and assess the privacy risk, identify and approve controls, and assign this responsibility for implementing controls. And finally, reassess if required and accept the risk.
Okay, that's great, Laurent. So effectively, we need to consider a DPIA when certain circumstances change. So bearing in mind that we are discussing this in the context of COVID-19, what are the type of changes of circumstance that would need to see in order to undertake a DPIA? For example, is there a change of employment situation, the introduction of home working and other such facets?
Yes, this process must ensure that the data processing has been assessed with regard to the privacy risk of the concerned person. It has been implemented to reduce or eliminate those risks. There are a series of triggers. Among them, and to speak more to the COVID-19 context, considering monitoring your employees' homework activity should meet both systematic monitoring and the data concerning vulnerable data subjects risk criteria, which make it likely mandatory to carry out an impact analysis.
Okay, so who has to do this within an individual company context?
The controller, meaning the entity or organisms which determines the purpose and means of the data processing. The controller should be responsible for carrying out a data protection impact assessment to evaluate the origin, nature, specificity, and severity of the considered privacy risk. The controller should do this in conjunction with the DPO in each company when designated.
Great. So we're in the COVID-19 environment. There are many law firms, very many offices, perhaps of 20 employees, of which 18 are now home working. Could you actually give an indication of the type of approach one needs to take towards doing a DPIA when, for example, 18 people are working at home now and perhaps only 2 in the office collecting the post? Would this require a DPIA, do you think?
In all likelihood, yes. It marks a change from previous working arrangement, and it would amount at least 2 of the triggers I've mentioned just now. A proper DPIA would need to consider matters such as how employees will share information with each other remotely. This could include who to allow access to video conference, and will you limit this access when sensitive issues are being discussed. It's important to note that this does not have to relate to software or Wi-Fi access. It can also be as simple as to where to leave files around the house and how to dispose of paper which potentially contains sensitive information on either clients or employees.
Okay, so effectively, it's not just related to IT matters, it's also relates to matters as banal as disposing or throwing some paper in a bin.
I'm afraid so.
Okay, that's fine. So bearing in mind that notwithstanding what we've just said relating to throwing paper in a bin, most of the issues that we are seeing now are related to software products and issues surrounding access to software, remote video conferences. Could you actually give a little bit of indication about what type of thing we need to be concerned about at the moment?
Well, unfortunately, cyber criminals are looking to take advantage of the pandemic. Phishing and cyber attacks have been on the rise during the COVID lockdown. Therefore, it's helpful to make employees aware of this threat and the importance of keeping personal data safe during the outbreak. Cases have included bogus emails with links claiming to have important updates, which when clicked on leads to the device being infected. These phishing attempts have been seen in several countries and can lead to loss of money and sensitive data.
Okay, so effectively the most important issue from the point of view of an employer here is to ensure that the lines of communication with the employees, perhaps who are home working, the lines of communication are kept open, and consequently that they're informed of relative policies and informed of the company policies as to the treatment of data issues.
Yes, absolutely. And also, the importance of keeping reports should not be underestimated. As organizations make changes to adapt to the challenge they are now facing, it's very important that relevant records being kept. Having accurate records of processing will help the organization to subsequently review and, when necessary, update any measure put in place during this period.
Okay, so practically speaking, Laurent, going back to our example of a company with 20 co-workers, of which 18 are working at home now, we've discussed the need to do a DPA. How do you do a DPA, and what are the steps to follow, do you think? And how do you demonstrate to an authority that you've actually made an effort to comply insofar as possible with the governing legislation?
As I mentioned above, I suggest to proceed step by step, as indicated in the stepped approach, in order to make sure that at the end of the day, we will have clearly defined and scoped the context of the considering processes, identify the risks threatening the personal data privacy, and most importantly, define the measures to take to mitigate the risk and comply with the legal aspect of the privacy protection.
So you talked about the foundations. What are the foundations we need to follow there in terms of where our risk lies at a company level?
It's quite simple. Number one, you need to make an assessment of the necessity and proportionality concerning the fundamental principles and rights, which are not negotiable and that are fixed by law and must be respected, whatever the nature, gravity, and likelihood of the risks. And number two, the risk analysis, which is the study of the data security risk, and makes it possible to determine the technical and organizational measures to be applied for protecting data.
So how does the risk analysis work? What do we need to be mostly aware of in undertaking a DPIA?
If we go more in detail into the topic of the risk analysis, risk to privacy for the person's content could be defined as a scenario describing, on the one hand, a dreaded event, such as an unauthorized access, an unwanted modification, or disappearance of data, and its potential impacts on the right and freedom of individuals. And on the other hand, all the threats that would allow it to happen. The combination of these two inputs, rated using criteria reflecting the likelihood and impact on the data privacy, allows to assess the risk and helps prioritizing the related mitigation measure implementation.
Okay, so we do have to consider the risk, we have to recognize them and balance them. So, and we have to accept a certain level of risk. So as a matter of fact, if somebody needs to create a DPIA, what does it actually look like? Is it a document? Is it a set of policies? Is it a complete document, or is it a work in progress?
Well, it's kind of both. When we conduct an impact analysis on behalf of various organizations, we are used to proceed arranging a set of 2 or 3 workshops in agreement with the controller, of course, that's of the future processing. The objective being to roll out our methodology, involving to get as many opinions collected and as much information raised as possible to exhaustively cover all the topics required by the analysis and produce an impact analysis report as a useful document, not only to demonstrate your accountability, but also from an operational standpoint to tweak your processes and improve the overall efficiency of your organization.
Great, thank you, Laurent. So effectively, we've arrived at a position where we have what Daphne said earlier, different interpretation in certain countries, depending on what the data authority in that particular jurisdiction is requesting, whether it be slightly more loose, as in Switzerland or the UK, or slightly more tough, as in France and in Italy. So what are the key takeaways here? Riccardo, in your view, what should we be concentrating on here and demonstrating that we've actually made an attempt to comply with the legislation, bearing in mind there is relatively little jurisprudence out there at the moment and a very specific legal environment in which we find ourselves in?
Well, Compliance, generally speaking, compliance. Comply to GDPR and the implementing law in your country. That's the first thing. You have to consider that you are exposing yourself to risk. Of course, those risks cannot be addressed theoretically because the GDPR does not provide specific fines, only a maximum for everything. And the maximum fine, the famous 4% of the turnover, is not usually applied, issued directly. There is a graduation before that, according to the case, according to the circumstances, according to the nature of the data. Also, you could receive an order to stop processing, which could impair your business. So care about compliance.
So logically, the DPIA is a necessary defensive act to protect one's business, both in terms of its operations, but also vis-a-vis the governing jurisdiction and governing authority. Okay, thank you. So Fabrice, turning to you, can we have a discussion briefly about the appropriate technical and organizational safeguards that one needs to put in place in a company and in these uncertain times?
Thank you for asking. Actually, beyond the financial risk, I mean, for the moment, most of firms probably consider GDPR as being a priority or their concern for the moment in this crisis time. However, I mean, what has to be considered, and also in general terms, but specifically now in this COVID-19 crisis, this GDPR can be a very good opportunity for the firms. Most of the people consider that GDPR is a pain, and we consider that, and you have to consider that as well, as being an opportunity. And specifically here, I mean, to prepare, I mean, the end of the crisis, the end of the lockdown, I mean, with GDPR putting in place. And for this one, DPIA is kind of a unique opportunity as well to demonstrate your accountability, your commitment, and how serious you are and how you protect the personal data and what are the different measures you are taking in your process just to make it done and be in compliance. But of course, I mean, this will, in this particular time, change the working practices, and DPIA has to be adapted to these new situations. But it's more to be considered as good for the restart after the crisis.
Great, thank you very much.
For the long term, and for the long term.
Excellent. So effectively, you're saying that a DPIA now is perhaps a good idea in the extent that we may indeed be seeing short-term changes in working practices now, but we may also be seeing a long-term change in working practices, which means that the companies themselves have to change their policies.
Absolutely. GDPR was
super. Thank you very much. We had, as I said earlier, one question, and we now have two, so we are exceptionally fortunate. This one really aimed more at Riccardo and Daphne, and this relates to a question we had, and specifically for home working. Can an employer monitor the actions of an employee?
That's a very intriguing question, because the European Union has not addressed such issue directly. However, we can find something. We can find a case law in the European Court of Human Rights, which is another organization, but it's very relevant in this context. That case, the case Barbulescu against Romania, was about an employee fired by an employer because he was spending too much time having private calls. The court says that by itself, monitoring an employee is not illegal. However, some safeguards must be in place. First of all, as you cannot rely on consent for the monitoring, as there is an employment contract in place, you have at least to inform your employees that they are monitored. Then there is a necessity test. Is it really necessary? Is it really something you want to do in order to check the loyalty of your employees? And last, the proportionality. The measure must be proportional. For example, you cannot take a screenshot of an employee's laptop every 5 seconds. You can, for example, have a call every 2 hours or so. So information, proportionality, and necessity.
Okay, and there again, we come back to the issue of communication from the centre to employees in their homes. We have just one other question, which I think is aimed slightly more towards Laurent, bearing in mind he was talking about the risk analysis undertaking in a DPIA. What happens if you are unable, or you feel that you are unable to get the level of risk down to an acceptable level vis-a-vis the treatment of data, whether it be health data or any other sort of data? And is it necessary to inform the data authority to ask their opinion, or do they have other things more important? Do they have other more important things to be worried about at the moment?
Yes, indeed. When you, after the DPIA, you still have a high risk remaining after the mitigation, then you are to publish the DPIA to the regulator. However, the objective of the impact study is precisely to reduce the residual risk. Otherwise, the processing should not be implemented, matter of fact. If the DPIA is communicated, so if a residual risk remains at some point, the regulator will necessarily ask you not to implement the processing. Why should publish the DPIA in such case? So the advice would be, okay, carry out the DPIA, just for the reason we have just explained so far, but come to the conclusion that the remaining risk is acceptable. Otherwise, it will mean that you should not implement your process.
Great, thank you very much, Laurent, and thank you for the audience for sending their questions. They were very interesting. We will, if you'd like to have any further questions or advice, please feel free to contact NADA on that email there. A recording has been made of this webinar should you want to visit and look at it again. And all that remains for me to say is to thank you very much for watching and to wish you a good day. Thank you. Goodbye.
Have a good day. Thanks for